democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers, who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government, was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive who are charged with formulating policies in the territory of NCTD would be excluded from controlling the civil service officers who implement such executive decisions. The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of all India or joint cadre services between the Union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now the conclusion. The division of administrative powers between the Union and the NCTD as explained in this section must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239 AA 3A D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the three entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239 AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239 AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of List 2 of the 7th schedule, because 1. The definition of state under Section 358 of the General Clauses Act 1897 applies to the term state in Part 14 of the Constitution. Thus, Part 14 is applicable to Union territories. And 2. The exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.